beginning this morning with Harley against State. We will then break for recess and invite you all to join us for coffee next door, and then we will reconstitute the panel and go forward.
Good morning. May it please the court.
Good morning.
My name is Edward Bauer. I'm with Brooks Luffman and Foster & Courtney, and I represent the appellant, Damion Harley. If I could reserve 2 minutes, please, for rebuttal. Facts of this case are pretty straightforward. The state's key witness, Investigator David Donato, testified during the proceedings below that in December of 2005, he met with a confidential informant at the Tallahassee Police Department, and the plan was to go to the defendant's residence and purchase a quantity of cocaine. Before they left, Investigator Donato photocopied a $20 bill so they could track the currency and hope to recover it later as corroborating evidence. When they arrived at the defendant's residence, they were told by someone in the yard that he wasn't there. They drove away, and the defendant's residence, the record reflects, was on Yorkshire Drive. Now, the record's not clear where Harley Street was, but that's the street where it so happens, as they were driving away out of the area, where they encountered the defendant. He was walking on the sidewalk. Investigator Donato pulled the car over. So you have Donato, the officer, in the driver's seat, the informant in the passenger seat. They pull up. At that point, the informant, according to Investigator Donato, engages the defendant in conversation. There's a drug transaction. The defendant allegedly sold the informant $10 worth of crack cocaine. So the defendant took the 20, handed back a 10, and 1 rock of cocaine. Now, before the defendant walked off, or as he was walking off, he informed them of what his cell phone number was, and then further stated, according to Investigator Donato, that if they ever needed any more drugs in the future, to give him a call. At that point, they drove away. The defendant was not arrested that day. He was not arrested on view. He was arrested on a warrant, I think, in February of the next year. So that's essentially the case. There were only 2 other witnesses that testified, other than Investigator Donato, the FDLE analyst, who simply confirmed that the substance was in fact cocaine, which was not an issue really in the trial. And finally, Investigator Garrick. And his testimony is very important, I think, if we get to a harmless error analysis, because it's important to see if we truly have a witness that can corroborate Investigator Donato's testimony. Investigator Garrick testified that his sole job in this operation was to set up surveillance at the defendant's residence, because that was the initial plan, to purchase the cocaine there. So what he testified to was that he was parked in a car, he was watching the residence, and what he said was he saw the defendant leave and walk off. That's the last he saw of him. Investigator Garrick also testified that at some point later, he observed Investigator Donato pull up in the vehicle with the informant. They spoke with someone in the yard who apparently he couldn't hear, but according to Donato, they were told that he wasn't home, and then they drove away. That's it. That is his sole involvement in this case. Now, the state, and I think this is important, in their brief...
Do we have to have another witness? I mean, we convict people all the time on the testimony of one witness.
With some of the errors that we've raised in this case, Your Honor, specifically the collateral crimes evidence, the reference to the possible future crimes, if the court finds that that is error, in Garrett, one of the cases I cite from this court, I think from 1987 or 89, they said where you have improper admission of collateral crimes evidence, the error cannot be deemed harmless where there is only one eyewitness to the crime and no corroborating evidence. So I think it's important.
Was there evidence tying the cell phone number to the defendant?
Well, that's what's important, because the state makes a big deal that the cell phone is somehow independent evidence. Only if you go through Investigator Donato. There is nothing inherently incriminating about a cell phone. Almost all of us have cell phones. The only evidence at trial establishing the number that the perpetrator gave out at the scene of the transaction was from Investigator Donato. And the only proof as to what the number was on the phone in the defendant's possession when he was arrested on the warrant months later came from Investigator Donato. There were no phone records, nothing else introduced. So the whole case goes through Investigator Donato, because the phone in and of itself is not incriminating. It's only potentially incriminating as to identity if you accept Investigator Donato's testimony. My point is everything here, including the phone, goes through Investigator Donato. And Investigator Garrick did not, and this is important. The state claims in their brief, and of course they're not trying to mislead the court, but they say that they identified the defendant as being at the scene. That was on page 21. And on page 30, they say, place defendant at the location of the purchase. That's just not correct. The location of the purchase, according to Investigator Donato, was on Harley Street. Investigator Garrick never saw him on Harley Street. He saw him at his own residence on Yorkshire Drive, walk out the door, and walk away, and that's the last he saw of him. So if by location the state meant planet Earth and the city of Tallahassee, that is correct. But they never, when I think of location of the transaction, I think the street where it occurred, that was Hurdy Street, and he never saw him there. So he did not see him approach the vehicle, did not observe the transaction. So truly, this is a case. 3 witnesses, Donato, Gehrig, who saw nothing, and the lab analyst. This whole case was based on Investigator Donato's testimony, which is important because some of the errors that we've raised. And if I could start, if it would please the court, with issue 2 that we raised in our brief, which deals with some of the arguments that were made. And I won't repeat the standard, but the theory we're going on is essentially that the defendant was deprived of a fair trial by some of the arguments that were made in the prosecutor's rebuttal closing, which was really only about 3.5 pages of transcript. I think it started in the bottom of 146 and ended on 149, but it was permeated, we believe, with improper argument. The first and most serious, which was objected to, timely and specifically, the state did not argue that it wasn't preserved. They've argued that some of our other arguments weren't preserved below, but they didn't argue that this one wasn't preserved. This was a community conscience argument. And the courts of the state have long held that attorneys, and probably even more importantly prosecutors, should avoid arguments that are intended to evoke a sense of community law through common duty and expectation. And our courts have held that these sorts of arguments they serve no proper purpose, and they carry the potential of substantial injustice. So with that sort of backdrop, what we have here, and I don't like to quote and read things during an argument because I have limited time, but I think it's very important. What she stated was, referring to Mr. Harley, he's the one who had the ball in his court. He sold in this community, our community. At that point, there was an objection which was overruled. He sold it in Leon County. In this community, our communities, our county, they are supposed to be sanctuaries, not, again, there was an objection which was overruled, not places where people sell drugs. And this clearly falls into a community conscience argument, referring to Leon County, using the word community 5 times, likening Leon County to a sanctuary, and then specifically referencing the defendant's alleged offense and linking it all together. Now, I don't think the state disputes that this was an improper argument. I think it's all going to come down to whether this was harmless error.
Well, part of that argument, I mean, it would be proper, wouldn't it? I mean, she has to prove venue, right? I mean, she has to prove it happened in Leon County, and to mention that it did in fact happen in Leon County.
Well, Your Honor, if you read the whole argument in context, it was clear that the venue, the whole issue here was the identity of the perpetrator. I don't think the defendant or the defense counsel ever made a point of, whether this was completely fabricated. Just do they have the right guy, and can we rely solely on the testimony of Investigator Donato? If you read the argument in its totality, which she was clearly not trying to counter some argument that this didn't occur in Leon County. She was saying that he had control, he had the ball. He's bringing this ball into our court in Leon County. This is our community. I mean, she said in this community, this community, this community, over and over and over. I mean, no one ever said this happened somewhere else. So it was not to defeat or counter some argument that perhaps this crime didn't occur in the Second Circuit or in Leon County. It was, and then the word sanctuary, that's completely indefensible based on the authority that we found to refer to perhaps characterize this county as a sanctuary. I don't know what she meant by that. Maybe Gadsden County isn't. It's okay to sell cocaine there, but not here in Leon County, which has this purported status as a sanctuary. But clearly the sanctuary remark is improper. And in the absence of curative instruction, based on the authority we've seen, generally these arguments are not deemed to be harmless. And we cite Burren v. State, 3rd District case, where the argument was much less severe in our view than what we had here. In that case, the defendant was charged with harvesting lobsters out of season, and essentially what the prosecutor argued was that the jury should consider the unfairness to the people that follow the rules, and essentially argued, well, because he's poaching or harvesting out of season, he's basically stealing from the good guys, the guys that follow the rules. And 3rd District held that clearly they had seen worse examples of community conscience arguments, but nevertheless, it fell into that category. And it held that in the absence of a curative instruction, the error could not be deemed harmless. And that's what we have here. Not only do we have an absence of a curative instruction.
What about Otero?
Otero, yeah, that was submitted a couple days ago by the state. In that case, it was a generalized argument where the prosecutor didn't specifically reference the defendant, I don't believe, or even the crime. I think the words in question were conscience of society. He was basically one of these introductory deals where thanks for being here, you're doing a great service, you speak, you're the conscience of society. That was the objectionable language. And the court held that that was an improper argument. That wasn't the issue. The issue was whether it was harmless in that case. In that case, the victim, someone barged into his house, stole his wallet, and drove off in the victim's car. The victim made a positive identification of the defendant, and further, the defendant was found in the victim's car with his wallet. So it was truly a case where the evidence was completely overwhelming, where you have inherently incriminating evidence, the victim's wallet, not a cell phone where we're depending on the believability of the officer to figure out if it's truly incriminating or not, but truly caught red-handed, and the court held it was harmless. Although it was a split-panel decision, Judge Ramirez, even with the strength of the evidence...
Well, is this even a conscience of the community argument? Isn't the argument simply that this is a serious offense?
No, I mean, the courts have held, Judge, that these, and I'll read from Burin, this is their quote, "Our condemnation of a community conscience argument is not limited to the use of those specific words. It extends to all impassioned and prejudicial pleas intended to evoke a sense of community law through common duty and expectation." And that, she's essentially arguing, convict this guy because this sort of stuff doesn't happen in our sanctuary of Leon County. It's just not appropriate. The question is, did the offense occur? It's not, and she wasn't arguing or trying to counter some claim by the defendant that this happened somewhere else and not Leon County. She was trying to raise Leon County above everywhere else and say essentially that an example needs to be made and they need to carry out their duty as jurors. And it's, I can't find any authority.
Well, there would be nothing wrong with telling them they need to carry out their duty as jurors. I mean, it would be an appropriate argument to say, you know, it's a difficult job that you have, and we are counting on you. In fact, in the jury instructions, the judge tells them that we are all counting on you to follow the law.
All I can say, Judge, is if you read her argument, just the repetitive nature, repeating the word community. This doesn't happen in our community, in our community, in our county, in Leon County. Our county is a sanctuary. When you read it all together and when you read the whole argument in conjunction with some of her other improper arguments and read it all together, this was going beyond what she needed to do to make her case, Judge. And if I could move on to some of the other improper arguments. Now, these were not specifically objected to specifically by defense counsel. I guess there's an issue about whether these are preserved or not, but we cited Lewis versus State in our brief, which was a unanimous decision of the 3rd District from, I believe, 2000, 2001, in which the whole court was sitting. It was 11-0 unanimous opinion. In that case, there were 13 improper arguments. Only 4 were objected to. And this was not a fundamental analysis, a fundamental error case. They were analyzing under the general rule of was the defendant denied a fair trial. And what they held was where some of the arguments are objected to, the court can consider all of the arguments in determining whether the defendant was denied a fair trial. Now, this opinion has not been cited very much, and it seems to have been ignored, but it's hard to ignore a unanimous en banc decision of the 3rd District. And the 3rd District was, and I'll read part of it because it's important. The 3rd District held, the State argues that because the defendant did not object to all of the objectionable comments, the issue has not been preserved for appellate review. Although the preserved errors in closing alone may seem insufficient to require reversal, we conclude that the Florida Supreme Court's decision in Ruiz allows review of all the comments made by the prosecutor during summation. And
I just want to alert you that you're into your rebuttal time.
Oh, thank you, Judge.
May it please the Court, Josh Heller on behalf of the State of Florida. I think the important thing, I'm going to go right to the closing argument issue, and I think the important thing to take from defendant's presentation is that you're supposed to look at the argument as a whole. You're not supposed to pull portions out of the rebuttal and say, and ignore what happened before it. And I think the first thing to consider when considering our community argument is to consider what exactly was stated by defense counsel in closing. During closing, defense counsel argued, we are taught in civics, well, officer-friendly, he's there to protect and serve us, we are to respect and like him, and that's what we're taught in society. In this case, defense counsel raised the idea of community values and norms and the community sensibilities. Accordingly, the State simply responded to that statement by defense counsel. Furthermore, even if the Court were to find that this argument is error, it's not a basis of reversal. Appellant has entirely ignored
What does sanctuary mean?
I'm sorry?
What does sanctuary mean? I mean, in closing.
Place where people are safe.
I mean, was the prosecutor lifting Leon County above every other county? We have special rules in Leon County, or?
No, I think, Your Honor, that people would recognize that, or would want to be safe in whatever community that they live in. I think that that's a pretty, excuse the pun, safe assumption to make. However, in Bell versus State, even if we were to assume that this argument is error, in Bell versus State, there was an objected to, the only reason we're here is that the defendant has a right to a jury trial. Now, we're talking about a constitutional right of the defendant that is involved in that case. And it was objected to, and the court determined that it was not enough for reversal, even over the objection. However, the reasons, additionally, we cited Smith, a 5th DCA case, that appellant claims the reason that that's not a basis for...
So opposing counsel thought you agreed that the argument was improper, but you do not agree.
No.
You really don't think the argument was improper at all?
I think that the argument taken in the context that this court has to consider it, which is the entire argument as a whole, was a fair and invited response to the presentation of community sensibilities by defense counsel in their closing.
So the suggestion that a law enforcement officer may have an interest in the outcome of the case and may not be completely truthful, and in fact admitted on the stand that he lied, I guess 2 times, that argument allows the state to bring up this is our community, this is a sanctuary, he did it right here in our community.
I think the reference to society, the pointing out that in this circumstance, the reference to what you're taught in civics, to that's what we're taught in society, those types of things raise the specter of a society as a whole. But even if the court does determine that the argument viewed in the context that it's supposed to be considered, which this is rebuttal to defense argument, even viewed in that context is not enough for reversal, particularly in light of Smith and Otero. That's a different argument, isn't it? I'm sorry?
That's a different argument. Now you're making a harmless error argument, aren't you?
Well, what I'm saying, Your Honor, is that it's not error here because it was a fair and invited response. However, if the court does not determine that it's a fair and invited response, that it's still not enough basis for error. And while the defense counsel attempts to resurrect additional arguments in their closing in an attempt to admittedly unpreserved arguments in their closing in order to create enough for reversible error, the fact is that if the argument is not preserved, then it has to arise to fundamental error, and despite and actually if the court looks closely at Lewis, it actually uses the term fundamental in it, and I would say that also referencing fair trial is the fundamental error standard.
Well, didn't the defense attorney make an objection several times, and as soon as the defense attorney gets objection out of their mouth, the judge says sustained? I mean, at least, isn't that really what happened? I mean, does the attorney have to keep objecting?
Well, this isn't a circumstance where we're even talking about continuing to object. What happened here is that the arguments about which defense counsel complains were at the beginning of the rebuttal. And then once we get to the end of rebuttal, there's this one statement at which defense counsel objects. There was no objection. And the reason I would suggest that there was no objection is that defense counsel recognized that these other arguments were fair responses to his continued attacks on the officer's credibility. And and even indicating that, well, he lied during this, can you believe him under oath? He didn't tell the truth, which I would suggest is a little bit of a misrepresentation of the facts, not telling a defendant when you're undercover that you happen to be a police officer when he asks is hardly a lie. But irrespective of that, it's challenged the credibility of the officer. Can you believe him under oath? And now all of those remaining statements are appropriately fair responses.
Well, I mean, technically it is a lie. I mean, it's one that, we accept as part of, undercover police work. But it seems fair to me that the defendant should be able to talk about that and say, raise that credibility issue, because it's an issue.
Your Honor, I do not suggest that defense counsel can't say that. But when attacking the credibility of the defendant, as defense counsel recognized below here, the state can get up in rebuttal and respond to those credibility attacks and buttress the credibility of its officer. Now, if we were talking about a circumstance where, the state had made a number of these arguments in close and not in its first close, and since we're dealing with a different framework now, every state argument is the first close, the facts would be a different situation. Those are different facts. But what we're talking about here is you have to view the argument as a whole. Looking at the argument as a whole, these were fair responses to what the defense had argued in closing. And the only preserved argument is not enough for reversal, even if this court were to determine that that was erroneous and not a fair response. The defense counsel also made reference to the unrelated crimes, his Williams rule argument. The state would first point out that this was not an unrelated crime. There is no unrelated crime at issue. This was part and parcel of what happened that night when the defendant could not provide enough drugs that were requested, and essentially said, give me a call in the future, and when you need to purchase more. That's not another crime. It's not another bad act. All of the cases that are cited by defendant are entirely distinguishable. They involve different crimes or different bad acts at entirely different circumstances. It's inextricably intertwined to what's happening, and it shows a number of important things, including the intent of the defendant, his knowledge that this was cocaine, the absence of any mistake that he could possibly claim, oh, I didn't know that it was cocaine, I didn't know that was, oops, it fell out of my hand, and that simply is not a meritorious argument. Additionally, defense counsel stated in brief that the state didn't respond to one of the questions with regards to the suspect question. The objection there was actually sustained, and there was no request for a mistrial with regards to the suspect question, so there really is no error for this court to reverse. Additionally, and the defendant got the relief that he requested in the sustained objection. And the only thing the state would add is that with regards to the third issue on the confrontation clause is that another reason that it's also harmless error is that the officer was sitting right there and watched the entire drug transaction. So whether or not the statement of the CI was a violation of Crawford, which the state maintains it's not, is insufficient to establish reversal. Additionally, jumping back, if I may, to Stempier. Stempier is also quite distinguishable from the closing argument in this case. The case first involved the prosecutor at the beginning of his close, shifting the burden of proof, and starting right out in the closing and doing so. It involved a particular fact situation, and it's not a per se rule with regards to closing argument. And there's also no indication that the community conscience argument made in that case was even made in rebuttal. It's unclear based on the case itself. So in the absence of any additional questions, the state respectfully requests affirmance. Oh.
With regard to the conscience of the community argument, I see that as one of your bigger hurdles to deal with. Go over again which cases you rely on in your harmless error analysis.
Your Honor, in Bell versus State, the argument there, I would argue, is even more problematic than the one here. In that case, the objected to argument was the reason that we're here is that the defendant had a right to a jury trial. And there it was objected to, and the court determined that was not enough for reversal, even over an overruled objection. In Smith has been extensively briefed, and the reasons that defense counsel claims that it's distinguishable from this case are that here, versus Smith, the objection was overruled versus the objection being sustained in Smith. However, if you look at Otero, the objection was not overruled once, but 3 times in that case. Additionally, the other reason that defense counsel claims Smith is distinguishable is that the argument wasn't repeated after the objection. Well, if the court looks at Otero, that's exactly what happened in Otero. And Smith and Otero are cited often together about the fact that here, where the argument is made at the very end of the state's rebuttal argument and does not otherwise permeate the state's closing argument, that it's not enough for reversal. Also, defense counsel mentioned Burren and indicated in brief that he couldn't understand why Burren was distinguishable. I think it's important to remember that when we're talking about closing argument, we view it on a cold record. And the trial court looks at it by looking at what happened. And this court applies deference to the trial court's determination. Now, what happened in Burren is after the argument, the trial court recognized on the record that you know what, I shouldn't have done that, and I should have given a curative instruction. Well, when an appellate court then looks at the record where the trial court has said that an instruction should have been given, it's impossible for the court to say that it's harmless. That's not the circumstance here. Here, the trial judge, who never indicated, as the trial judge did in Burren, that the error was one that should have been given a curative instruction in order to fix, that's not what happened here. And it's that level of deference that's appropriately provided to the trial judge, who sees the argument, sees the effect of that argument, and witnesses it, that's important. And that's why Burren is inapplicable to the facts at issue here with regards to the harmless error. Accordingly, the state respectfully requests affirmance.
Getting a trial judge to admit that they were wrong is some sort of prerequisite for getting a reversal. We could send your honors home. I cannot understand how they try to distinguish Burren. The only difference between Burren in this case, other than the fact that the comment in our case was worse, is that the trial judge, as he says, admitted during a post-trial motion hearing, you know what, I should have given a curative instruction. That's neither here nor there. The trial judge's opinion about what he should have done is completely irrelevant. All that matters is what happened in the presence of a jury during the trial and the fact that the objections were overruled. I fail to see how the judge's personal opinion about whether they're wrong or not is a valid basis for distinguishing this case. And this is very important. The state is arguing today that the community conscience argument is fair and invited. I challenge the court to start on page 29 and look back through the brief, which of course you all have read, but that argument is not raised in this brief anywhere. This is what they say. Any error that may have occurred from the prosecutor's argument on this point, however, is harmless beyond a reasonable doubt. That is the only argument they present is harmless error. Nowhere do they cite any authority or make any argument whatsoever that this argument was invited. Now, they argue that some of the other arguments were invited, like the personal expression of guilt and vouching for the officer. But what he's saying today has been raised for the first time in this oral argument. It was not raised in brief. Had it been, I would have responded to it in my reply. They simply argue harmless error. And we would submit that you cannot have a harmless error where we do not have a second corroborating witness. We do not have fingerprints. We do not have an audio recording. We do not have a video recording. We do not have an on-view arrest. We do not have a post-Miranda confession. This is simply a case where we have one witness saying something happened on a particular day. And if I could respond to this invited response argument, I got 10 seconds left. Public defender was just doing his job. He was just pointing out that there was no corroborating evidence. And it's sad if we're at the point now where someone is doing their job and pointing out the lack of evidence, which an appropriate consideration is a basis for vouching for law enforcement. Thank you.
Thank you. We will be in recess at this point.